Okay, why don't we go ahead and get started? Hello, everyone. It's good to see everybody on the screen and in the room. I'm sorry I have my back to you guys. Welcome to our October Family Forum night. It's good to see everybody, and we're going to get started. The first thing I want to kind of go over real quick is if everybody can go ahead and mute themselves, that will prevent that background noise or that feedback. Okay. Tonight's topic, as you all know, is guardianship and guardianship alternatives. And we have Kristen Henry, who is the Executive Director of Apsey, which stands for Advocacy and Protective Services, Inc., here to talk to us about that. We will be sharing screens so that you will see the PowerPoint as she goes over it. If you think of any questions, go ahead and jot those down, and we can ask those at the end of the presentation, or you can put them in the chat box. And I will try to keep an eye on the chat box for you. We are recording the session, and we will post that along with the PowerPoint on our website. Okay, so that you can go back, you can re-listen to it, you can share it with somebody that wasn't able to come tonight. Okay, any questions? All right, without further ado, Kristen, I'm going to let you take it.
All right, thank you, Jody. I'm going to bring up my screen here. All right, so I really appreciate the invitation to come speak today. This is a topic that is really important to me because at Apsey, we serve as guardians for adults with developmental disabilities across the state of Ohio. So for those of you who are not familiar with Apsey, I want to start out right there and then we'll get down to the meat of what I'm here to talk about. So right now we're working with about 3,200 adults across the state of Ohio. And about 70 of those individuals are residents of Lake County. We are the only statewide guardianship program and the only program that specializes in serving adults with developmental disabilities. As I'll talk about later, there are different types of guardians, and at Apsey we serve as guardian of the person. And so I'll get into a lot of details about what that means. But basically it means we're not handling people's money or any property they may have. We're focused on making those decisions about where they're going to live and what kind of care they're going to receive. And at Apsey, we exist because there are some individuals who don't have family members to attend presentations like this for them. They need someone who can help make decisions for them, and they don't have a family member or a friend or someone else in their life who can do that. And so we serve in that role. We are available 24/7 to provide consent for our clients. And what's a little bit unique about Apsey, and actually some laws are being changed to allow other programs to operate this way, is that Apsey, the organization, is considered to be the individual's guardian, not our individual staff person. So we are able to wrap services around people and use some specializations within our staff to make sure that people get the consent that they need for the services that are important for them. So this slide is actually a new addition to my presentation because I talk to a lot of families about guardianship. And through some questions and comments and just chatting with some of those families, I realized I needed to start these presentations and be a little bit clear about something, because I think a lot of families come to this presentation because they need to know about guardianship, and they know that they don't know enough about it and they want some resources. And so I don't know if you can see my mouse here, but I'm circling the words resources and I'm circling the word guardianship, because this is what people want to hear about or think they need to hear about when they come to these presentations. But I'm actually going to start down here at the bottom of this pyramid. We're going to lay the foundation to make sure that you know the most important things about guardianship. And so I'm going to start with some key takeaways. And then we're going to move to understanding what capacity and competence mean. Those are not just important words and legal terms, they're really important to figuring out the rest of this pyramid. So in order to know whether an alternative to guardianship is appropriate in your situation or whether guardianship is necessary, you need to know about capacity and competence. And then we like to talk about guardianship as a last resort or the most restrictive alternative. And so we want to go through these other decision-making supports before we get to guardianship. But if you're listening to this first part of my presentation and you're like, I need to know about guardianship, I want you to know we're going to get there. We're going to get through all of this today. And I promise to spend as much time on your questions as we need to. And at the end of the presentation, you'll also have my contact information, and I'm happy to answer questions or direct you to other resources, even after the presentation's over. So I also want to let you know I come from a couple perspectives here. So I come from the perspective, as Jody shared, as Apsey's executive director. But before I was here at Apsey, I was an attorney, and I spent a lot of time working with individuals who had guardians or family members who had questions about guardians. And so I'm going to try to share as much as I can about court processes and legal requirements and all of that. All right, so let's focus on those key takeaways. And this is where I would say, you know, if something comes up 5 minutes from now and you miss the rest of this presentation, first of all, I hope you'll come back and watch the recording, like Jody said, but you'll at least have some of these really important ideas that are important when we're thinking about guardianship and alternatives to guardianship. The first thing, which sometimes families are not really told, is that guardianship is not mandatory for all people who have disabilities. There are lots of different ways to support people. Some people might have a specific diagnosis, but be very independent. And so just because your child, your adult child, your loved one, your friend, whoever it is you're thinking of when you think through this presentation, just because they have a certain diagnosis does not mean that they have to have a guardian. And so we want to think through what is the right solution for their situation, because it is important to make a choice. There's not just one choice, but it's important to make a choice about whether you're going to move forward with guardianship or alternatives, especially if you're thinking of someone who's maybe getting close to that age 18. The right solution, though, depends on a lot of factors. Diagnosis or, you know, maybe something like an IQ level, that's going to play a part. You know, I'm not going to say that it's irrelevant, but it's one factor. Lots of other factors will come into play that we'll talk about today. And the most important factor can be time, because a person's abilities, a person's skills with decision-making can change as they age, as they gain experience, as they receive different services, as they have different people in their lives. And so that right solution can change over time. Guardianship is not a one-time decision. But we do like to caution people that guardianship does not solve or prevent every problem. I know, especially in working with parents of transition age youth, there's a lot of worries, and that's not disability specific. There's a lot of worries if you're sending your children off to college, or they're moving out for the first time, or there's a lot of things to be worried about as a parent, right? And so guardianship does not necessarily solve or prevent all of those worries that keep you up at night. Because in the end, sometimes relationships matter more than legal authority. And I'm going to talk about that a lot more later. Some family members, though, do have a misconception that they are their adult child's natural guardian, and that because their child was receiving certain services or had a certain diagnosis before the age of 18, that when they turn 18, that they are automatically their child's guardian. That is not the case. Guardianship is a very specific legal process that you have to go through if you do think that you need to become the guardian. And again, we'll talk a lot about that at the end of the presentation. And then perhaps the most important thing for you to know is that I won't be able to answer every single one of your questions. And that's because there are a lot of gray areas in guardianship. There are courts that answer questions differently. There are judges who answer things differently, maybe than I would or than each other would. And so what I'm going to try to do is point out to you areas where there might be a difference of opinion or a difference of understanding, and how you can get some answers that would be specific to your situation. So again, if you tune out the rest of this, if something happens and you miss the rest of this, watch that recording, but these are some of the most important things that you'll hear me say today. The next thing is, because I think a lot of people who come to these presentations are thinking about the needs of their teenager or young adult. And so based on some conversations that I've had, I put together this kind of suggested timeline. So I want to be really clear. This is something I made up. It's not, a legal requirement. It's nothing but based on my experience and kind of a legal timeline laid over it. And so the first thing that I want to say is the best thing that you can do, no matter what age your child is at here, is to do more than one of these presentations. I hear from a lot of parents that, they pick things up from these presentations, but it takes 2 or 3 or more to really know what it means for their situation. Because especially if this is the first time you're thinking or hearing about guardianship, there's a lot. I'm going to be talking for a while tonight. And so there's a lot to know, a lot to pick up, a lot to assess about your situation. So don't be afraid to go to 2 or 3 or more trainings about guardianship, because I pretty much guarantee you'll pick up something helpful every single time. It'll help you move towards that decision. So that applies no matter what age we're talking about. If you have a child who is under the age of 14, this still applies to you. Think about, what are your goals for your child? What do you hope that they'll be able to do when they're 18? What is their current capacity compared to maybe their same age peers? What are you projecting their capacity to be when they are a young adult? These are things you can be starting to think about as you're planning for services. Once you get into that age 14 to 16 range, I think that's really where you start hearing the word transition a lot. And maybe transition age youth, you'll hear me say that quite a few times. And so as you're planning for that transition, whether at school or with DD services or whatever else, you should be starting to identify those services that can help prepare for that transition. And again, I'll touch on more specifics in a little bit. And then you should start deciding. You don't need to make a final decision, but you should start planning out what you think is going to be the right decision-making support, so that you can start kind of heading down that path. Once your child is 17, this is where we really get into that preparation phase. Whether you're talking about guardianship or alternatives, you really are going to want to start taking action steps after they've turned 17. That might include meeting with an attorney if there are legal documents that you want them to work on. It definitely means understanding the court process. How does your specific local court handle things like when things should be filed, when hearings will be scheduled, all of those things. And then you can start executing that plan. Once your child is 18, definitely want to be in execution stage. But like I said before, we're not done. So even if you determine that guardianship is appropriate when your child turns 18, or that an alternative to guardianship is appropriate, we want to continue developing those decision-making skills as much as possible. And we also want to continue identifying services that can help with that. And then make changes as necessary. Maybe someone needs a guardian for 5 or 6 years as they are a young adult, and then they develop that independence and those decision-making skills, and they're ready to not have a guardian. Maybe you try out an alternative to guardianship and something changes in the situation and it's not working out the way you had hoped, and you need to move into guardianship. That's something we can continually be doing throughout the lifespan. All right, so we're going to move from those key takeaways up one step in that pyramid into competence and capacity. And what I'm really talking about is, what are our skills for making decisions? And then also, how do we assess a person's ability to make decisions? So that's where I like to really closely distinguish between capacity and competence. Capacity is a pretty qualitative term, and I like to summarize it as the ability to make a specific decision at a specific time. Do I have the ability, the understanding, the information that I need, whatever, to make this decision? And that's where you get words like incapacitated. And so someone who maybe is in an accident or intoxicated or something like that may lose their capacity for a short period of time or a long period of time to make a decision at that specific time. And that's where capacity fluctuates a lot. It can be different in the morning than it is in the evening. If you take a certain medication that either affects your capacity or improves your capacity. It can change over time if you have a progressive condition. So I think the easiest example to think of there is something like dementia, where a person has full capacity and then over time might start to lose some of that capacity. And again, might have more capacity in the morning than in the evening or something like that. Capacity is important when we're talking about guardianship or alternatives to guardianship. So most of the alternatives I'm going to talk about today still require that the person has capacity to understand what they're asking someone else to help them do. So you're going to hear me repeat this a lot while I'm talking about guardianship and alternatives. And the reason that I mention that is because I have talked to families who say, you know, my son has a very significant impairment in their, they have a very significant intellectual disability. They really have no ability to take care of themselves. They require full support. They, you know, really aren't able to make decisions. But I'm philosophically opposed to guardianship. And so instead, we're going to do a POA. Well, legally speaking, that may not actually be possible, because even to have a POA, a power of attorney in place, which I'll talk about more soon, a power of attorney requires the person to have the legal capacity to understand what they are asking someone else to do on their behalf. And so someone might not even have enough capacity to use an alternative to guardianship. And so that's where capacity matters. Competence, while it's related to capacity, it doesn't mean the same thing. Competence, what we talk about today with competence, is a legal determination. And so when we talk about guardianship, incompetence means that the person is incapable of taking proper care of the person or property. That comes straight from Ohio law, Ohio statutes. And so it can mean different things in different places. So you might have heard the term incompetent to stand trial related to criminal actions. And that's different. Again, there's some overlap. You know, some people who are incompetent for guardianship purposes are also incompetent to stand trial, but it's not exactly the same. Some people might be incompetent to stand trial and not need a guardian. Some people might have a guardian and not be incompetent to stand trial. So we have to make sure we're using that term in the right way. So as we're looking at capacity, some of the tools that I like are, first of all, this charting the life course tool. And that's because capacity matters in so many different places in your life. You know, it matters related to your day-to-day decisions. What am I going to do today? How am I going to get myself ready for the day? How am I going to get myself to my job or my day program? Do I want a job? How am I going to decide what I'm going to do with my life or with my day? Do I understand my medical condition and the medications that are being prescribed to me? There's all these different things. And if I asked you to just list out all of the decisions in your life, you know, it's hard when you put somebody on the spot like that. And so this tool for exploring decision-making supports, what I like about it is it's a several-page tool that goes through a lot of different detailed areas of those different things I was just talking about. And then the person or their parents or a counselor, a teacher, someone in their life, multiple people in their life, can kind of fill out this questionnaire, and it lists those different areas, life areas, and then it says, can the person do this totally independently? Can they do it with support, or can they not do it on their own? Do they need full support for that? And then as you fill out this tool, it kind of helps to guide you by seeing where somebody is very independent versus where they need full support, can help you show, do they need a guardian? Do they need a limited guardian? Could they just use supported decision-making supports? Because most of those answers are in the middle. It really helps assess where they have capacity fully, where they have limited capacity, and where they need full support from someone else. Another tool that I like is called the American Bar Association Practical Tool. Practical in this case is an acronym that stands for all the different ways that you should be looking at a person's strengths and needs and alternatives to guardianship before landing at guardianship. So I find both of those to be very useful. I will say, I think Jody said the slides will be made available. Sometimes they change up these links on me. So if it turns out one of the links isn't working, I'll make sure to get another one to you or a copy of the document. So I talked before about building capacity, that decision-making is a skill that can develop over time. And so I really encourage people that if you see an opportunity for that skill development for your child or the other person in your life, think about the different plans that you are part of for them, their IEP at school. If they're connected with opportunities for Ohioans with disability, that's vocational rehabilitation. They would have an individual plan for employment. If they have DD services like a Medicaid waiver, there's the individual service plan. And so those are all opportunities to say, you know, they need help getting more independent at their money decision making. How can we build that skill for them? What services are available? And then I also like to emphasize that guardianship or not having a guardian doesn't mean that you are fully independent. So plenty of people who don't need a guardian still get supports. They still get services in their home because physically they need help or they need help with someone around the house, something like that. And so assistive technology can be another way of getting that support. So, you know, memory may be an issue related to capacity, and how many of us use our smartphones to help us remember things. And so if it's not a decision-making issue, but more of a, you know I need to pay my bills. I know I need to make sure I have enough money, but sometimes I forget when my bills are due. You know, reminders can be very helpful for that. There's lots of apps out there, lots of technology that can be used to support people who need reminders or who need to find extra information or who need to connect with the people supporting them to make decisions. So let's be creative as we're looking at ways to support people. All right, so now let's dive into some of those alternatives to guardianship. I've mentioned a few of these already. The reason that we consider alternatives to guardianship is, number one, in Ohio, we're required to. So our probate court rules say that if, or our probate court laws say that if an alternative to guardianship is appropriate and information is provided about that, the court is required to consider it, even if someone is applying for guardianship. But even more than that, our rules about guardianship in Ohio say that if there is a guardian, that guardian has an affirmative responsibility and an ongoing responsibility to determine whether the person still needs a guardian, and if they don't, to bring that to the attention of the court. So we always want to be thinking about whether alternatives to guardianship would meet a person's needs. And you probably hear the term least restrictive a lot. You know, at school, we're looking for the least restrictive environment. So we always want to do what's least restrictive for people. And if you're looking at these alternatives to guardianship on kind of a spectrum, guardianship is certainly the most restrictive. It is long-term. And actually, I've heard some families say that they didn't think it was long-term because they know they have to file a report with the court every year or every 2 years. And so they only essentially have guardianship for that year or 2 years. That's actually not correct. So guardianship is indefinite unless a court specifically says that it's for a shorter period of time. And so you still want to think all the time about whether guardianship is appropriate. And then there's also that court involvement. You know, some people don't want public court involvement in their private life. And so it's something to keep in mind. I'm going to mention later that the probate court is the superior guardian when we're talking about guardianship. And so that means that sometimes the probate court can direct a guardian to do something. And so some people prefer not to have that involvement if they don't need to. But then in my mind, maybe some even better reasons to consider alternatives to guardianship are because they can actually be more effective. They can meet people's needs. There's research that shows a positive connection between that kind of self-determination, making decisions for yourself, and better health, safety, independence, integration into the community. And so there's all these good reasons that we should consider alternatives to guardianship. So as we're assessing what options are right for a particular situation, it's important to keep in mind that guardianship does provide important legal authority, but as I said before, it doesn't solve or prevent every problem. And so that can come in a couple different ways. Number one is this idea, and it's very understandable, I think. I think as parents, we always want to protect our kids. And especially if you're a parent of a child or a young person with disabilities, you have spent so much time advocating for them, trying to protect them from harm, trying to do what's right for them, that sometimes we forget that sometimes a little bit of bad stuff isn't all that bad. We've all made mistakes. We've all made the wrong decision. And dignity of risk, which I have here on the slide, means that there's actually some character growth. There's actually some learning that comes from making the wrong decision and experiencing the consequences of that, and then figuring out what to do differently next time. And it's hard, I think, as parents, because we never want bad things to happen to our kids. And it's hard sometimes to draw that line. What is, kind of a mild consequence that helps someone to grow versus a really destructive situation. And so as we're looking at that, especially when we're talking about things that aren't going to kill someone, aren't going to get someone convicted of serious crimes, is there some benefit to letting people kind of step out and make a decision that may not be the best? And then it's also important to recognize that we all make decisions that other people think are bad. And I feel like the number of years that I make this presentation, this has become more and more apparent because we are constantly criticizing each other's decisions right now, whether we're talking about, how we vote, or what decisions we're making related to COVID. There are really strong opinions on each side. And we, like I said, we criticize each other's decisions. And so it's hard when we are assessing a young person's ability to make decisions or how much risk they should take. It's hard because we see that there's not always agreement between reasonable people about what a good decision looks like. And so that's just an important thing to keep in mind. Again, it doesn't show you for sure whether guardianship is right or an alternative to guardianship is right, but I think it kind of helps us take a little bit of a slower thought process to it, a little bit of a deep breath, instead of feeling like, my child can't make those decisions. They can't be responsible for those decisions. We have to become the guardian. And, I think this is an example of a couple of things I've talked about. When I used to do these presentations, 5, 6, 7 years ago, my sisters were in their mid-20s. And so I would spend a few minutes at each of the presentations talking about their most recent bad decision and kind of how my parents would love to become their guardians, but my sisters don't have disabilities, and so that's not legally an option. And so it kind of shows that we need to give people that room to make some challenging decisions. And actually, I feel like over time, I'm able to talk about this differently because my sisters are in their 30s now. And so I don't have stories to tell because, as I said before, their decision-making has grown over time. And so there's not as much to talk about now, which is great. I'm glad for them. I'll have to make some new young friends who I can talk about their bad decisions or something like that. But it's important to keep in mind, as you're worried about your child who's turning 18, if they potentially do have that capacity and they could work without a guardian, then think about maybe yourself going off to college or starting work after high school and how confident you were or probably weren't in all of the things you were doing. And so what is the equivalent? How can we support people through that transition? This next part, though, really what I try to emphasize here, relationships are as important as legal authority. And what I mean by that is, if you have a relationship with your young adult or not so young adult where they are receptive to your opinion, they are looking to you for guidance, they're willing to take your suggestions about the decisions that they should make, then it may not matter whether you're the guardian or not, because it sounds like maybe that decision is going to end up the same whether you're the one legally making it or they're the one legally making it. And so if there's that good communication and relationship, that may be a reason why guardianship isn't necessary, because supported decision-making, for example, would be a good alternative. On the other hand, if there is a lot of conflict in that relationship and someone who is not willing to go along with suggestions or advice that's given, then unfortunately, even as the guardian, you're still going to experience some difficulties. I hate to put it that way, but at Apsey, we specialize in serving people who have really significant needs, maybe have a lot of conflict in their lives, and we can make a decision for someone. We can sign off on that plan. We can consent to that medication. But if they're not willing to follow through with it, there's kind of a limit to what we can make happen. And so we really work on building those relationships so that when a tough decision needs to be made, we know what the person wants, we can do what's in their best interest, but also as close to what they would want as possible, and then work with them to make that their reality. Because in the end, we can consent to a medication, but we can't ingest it for them, for example. So that relationship is really key and can help you decide what decision-making support is right for your situation. So again, you know, we want to consider all of these things as we're assessing different options. So as we look at different alternatives to guardianship, the first one that I put on here is not so much an alternative to guardianship as just how people live their lives. And so when I say informal supports, that's not really a thing. It's not a form. It's not anything. It's just a description of what people do for each other. And so informal supports are, you know, you've got a 19-year-old who has a new medical issue, not really sure what questions to ask or what needs to happen. And so their parent comes to the medical appointment with them. That can be if they have a disability or not. Same, maybe you have parents who are aging and they're dealing with a medical situation and you go to an appointment with them, or they need to make some changes at the bank, but they want to make sure they do everything. And so you go to the bank with them and you're just kind of with there, you make sure that they get through that list of everything that they need to do. That's informal supports. Nobody has to give you permission to do that legally. It's just, did the person ask you to be part of that appointment? Did they ask you to come along and be part of that conversation? So those are informal supports. Supported decision-making kind of takes that to the next level. It's just a little more planful. It's a little more intentional. It's something I'll get into actually on the next slide. So I'm going to hold off on going into a lot of details there. But again, it's just taking those informal supports, those conversations that are naturally happening, and taking them just a little bit more formally. Releases or authorized representatives. This is what I mentioned when I hear from parents that they feel like they need to become the guardian because the doctor's office won't talk to them once their child turns 18. And so that is true. I mean, legally that is true, but guardianship is not the only option in that situation. If the child has a good relationship, like we just talked about, there's a good relationship there between the parent and child, the child can give a release to the doctor's office that the parent can call and help schedule their appointments or get their medical records or whatever, be part of those appointments. Authorized representative, that's usually for a government program, but the same kind of thing. It's giving permission for someone else to help you handle those things. Powers of attorney take us, again, just up to the next level. So a power of attorney is a legal document that a person signs basically saying, I am choosing you to act on my behalf in a way that I'm authorizing. In Ohio, we recognize healthcare powers of attorney, which means if I'm not able to make a decision for myself, someone else is going to make that decision for me. And I'm designating this specific person to do that. We also have financial powers of attorney. Sometimes actually you see these for someone, maybe a couple is purchasing a house, they live out of state, only one of them can come in for the closing. And so the person who can't be there in person will complete a power of attorney and allow the other person to sign those documents for them. This is where I give a plug on powers of attorney, that powers of attorney are not just for people with disabilities. Powers of attorney are for everybody. Any one of us could be unexpectedly incapacitated tomorrow, an accident, a medical condition, anything. And so having someone designated in writing to make those decisions for you if you can't make them for yourself is critically important. Powers of attorney in Ohio, there are forms that are available online, forms that are approved through our laws, or you can meet with an attorney, and a lot of attorneys have more tailored or more specific forms that they work through with you. But again, good idea for everybody to have. If we're talking about financial matters, there's a lot of different ways for someone to manage someone else's money. That could be through a trust. If we're talking about a large amount of money, especially an amount of money that might cause someone to otherwise be ineligible for benefits. You could have a payee. So most of our clients at Apsey don't have a guardian for their money, but they do have a payee for their Social Security funds. And so the payee gets those, make sure their rent gets paid, make sure their utilities get paid, gives them personal spending money, all of those things. And then stable accounts are a great, I'm going to say new, but that's just because I guess I've been doing this for too many years because they've been around for quite a while now. Stable accounts are a newer way that people can save money without becoming ineligible for benefits. And that money can be used for almost any purpose. And all of these things, trust, payees, stable accounts, you could have another full presentation about this. And I think that's a great topic for another family forum if that's not one that you already do. Because again, I could spend an hour going through all the details of trusts and payees and stable accounts. Conservatorship is a term that I like to cover because we've been hearing it more in the news. And that's because Britney Spears, we all know now, Britney Spears is under a conservatorship. Well, conservatorship in Ohio is different than some other states like California. In California, conservatorship basically means guardianship. In Ohio, conservatorship means basically a voluntary guardianship. And so a conservatorship is something that also goes through the probate court. And it's where a person says, I want this person to fully act on my behalf. I'm competent, I have capacity to make that decision, but maybe I have a significant physical disability and it's very hard for me to get out to the bank in order to make financial changes. And so I'm going to ask for this person to be my conservator. Guardianship itself can also have some less restrictive alternatives, like limited guardianship. So for some people at Apsey, they're pretty independent, but they've got a complicated medical condition. And so we are only appointed to make their medical decisions. They can decide where they want to live, what other services they receive, and we just sign off on maybe the surgeries that they need or the medications that they're going to take. And then, as I said before, capacity matters for all of these things. To set up a power of attorney, to give a release, all of those things require that capacity. So I want to spend a few more minutes talking specifically about supported decision-making, because this is one that's really exciting and it's really a movement. In Ohio, we don't have a specific supported decision-making process. Other states have put it specifically in their law. I think Missouri is one, Texas, Indiana are examples of places that have a supported decision-making law. In Ohio, it's an idea, it's a philosophy, I would say, that we follow. And it's about working with the person to identify the areas where they might need some help making decisions, and then just putting a plan in place to get them that help. And so you can think of it this way, like a very real life example that's not supported decision-making, but is the same concept is think of something that you don't know a lot about or don't feel really comfortable with, but sometimes you have to make that decision. For me, it's my car. I know how to drive my car pretty well, but I don't know all the stuff that goes on inside of it. And so when I go to get a car repair or some maintenance, and they say, oh, yep, we did your oil change and you need this long list of other things done to your car. I don't know if that's true or not. I don't know if they're giving me a good price for it. And so the person I call is my father-in-law. He knows everything about cars. And so I can say to him, you know, they're suggesting that I need this replaced and this fluid exchanged, and they want to charge me this for it. And sometimes he'll say to me, yeah, that's a great price. And you've got 100,000 miles on your car. That's the time to do that replacement. Other times he'll say, there's no way. You don't need that. I can do that for $5 with a part from Advanced Auto Parts or whatever it's called. We can do that together. And so that's, if you want to look at supported decision-making that way, he's my car support for decision-making. And so let's kind of extrapolate that out to all of those other different life areas. And so maybe the person doesn't really need help with medical decisions because they don't have a complex medical situation, and they go to their annual appointment, they get their flu shot, they get their COVID vaccine, and that's great. They've got enough information to make those decisions. But they need some help with finances. You know, they really struggle with that. And so maybe they will designate a person. Maybe they'll say, hey, mom, can you plan to come over twice a week? And we're going to go through my bills, make sure I know what I'm paying, help me decide how I'm going to budget for that month, those kinds of things. Maybe they want someone to come with them to their DD team meeting to make sure that they're accurately identifying their needs and getting the services that they want. Any of those things, any part of their life, they can figure out, I might need some help with this, and here are the people that I trust to help me make those decisions. And so that's why it says here, supported decision-making, or SDM. It looks different for every person. Not everybody needs help with the same things. And some people have very close family members who can help them. Others have coworkers or friends or people in the community. It can be as wide open as you might want. And at the end of the presentation, I've got a lot of suggestions for resources for supported decision-making. So I said before that Apsey is really excited about supported decision-making, and we are doing this in a few different ways. First of all, I would say we try to use supported decision-making for all of our services. And so even though we may be the appointed guardian, we want to be involving our clients in their decisions, supporting them in that process to the greatest extent possible. And so we may be the ones who have to sign that consent form, but we want to support our clients in making the decisions that affect their lives. We want that to be the least restrictive support that it possibly can be. And everybody can do that, not just Apsey. Any guardian can involve the person that they are guardian for in their decisions. We also have some specific initiatives. So guardianship to restoration transition is something we're doing where we're looking at the people we're serving as guardian and figuring out what would it take to get them out of guardianship. Are they ready now? Could we identify some people that if they do have a question or a concern that they can call? Could we get the court to end their guardianship now? Or do they need some of those services to develop their decision-making skills? And if so, what are those services and how can we get them for them? So that's how we're doing guardianship to restoration transition. The other thing we're doing is something we call targeted decision-making. And that's because sometimes people get referred to Apsey for guardianship when they really just need help with one time-limited decision. Maybe they are trying to decide where they need to live, or whether to choose this provider or this provider. And if they don't have a family member or friend who can help them with that, that can be something that Apsey can help them with. And then maybe that's a 2 or 3 month thing that we work with them on, and then they go on with their lives and we go on helping our other clients. And so we just try to come alongside people and provide the support that they need in that moment at that time when they don't need a guardian. Okay, so now we're getting up to the tip of that pyramid. And if you have been waiting to hear about guardianship, here we go. So the role of the guardian is to make decisions for people who can't do so themselves because of their disability. I mentioned before, guardians have to be appointed by a probate court. If you have not gone through a probate court process for an adult, you are not actually their guardian yet. It's not an automatic process. But the good news is, if there's a reason, if there's evidence that the person needs a guardian and there's a family member who's willing to do that, then it's pretty routine that courts do appoint the parent or other family member to be that guardian. The main thing that guardians do is provide informed consent. That can be across a lot of different life areas, but in the end, that's what we're doing. We're giving consent for something for the person. But it's important that it's within the scope of our authority. We can't be making decisions about things that a probate court has not given us that authority to do. And so that's where it's important to know the different types of guardians. I said at the very beginning of a presentation that APSI serves as guardian of the person. And so what that means is it's all those daily living decisions. Where is somebody going to live? What's going to be in their service plan? Who's going to help them at home when they need help? Where are they going to go during the day? What other supports do they need? What medical care will they get? What psychiatric care will they get? What medications will they take? We give consent for all of those types of things. On the other hand, a guardian of the estate handles money. And so those alternatives to guardianship that I talked about, like trusts and payees and stable accounts, the equivalent there in guardianship is guardian of the estate. Any of these guardianships could be limited. So I mentioned before about limited guardian of the person for medical decisions, or you could have a limited guardian of the estate only to handle a certain pot of money that the person may get. I also like to mention, because this can be a little off-putting for families, the legal term for the person who has a guardian is ward. And that's kind of an outdated term. We usually like to say person under guardianship, or at Apsey, we talk about our clients or the people we serve. But the legal term for that is ward. The guardianship duties, like I said before, you're going to provide informed consent. You're also going to follow those court orders, court rules, and the Ohio Supreme Court's rules on guardianship. And that's because the probate court is the superior guardian. They, in the end, have the highest authority of what the guardian can do or not do. And so, for example, a guardian of the estate must get permission from the court in order to spend any of the person's money. Guardians are required to get an initial 6 hours of training, and then annually after that, 3 hours of training. I think Jody had mentioned before that they are involved in some of that training locally. There's also online training options created by the Ohio Supreme Court that are very good. And really those can be helpful in learning about mental health, about benefits, excuse me, about DD services, so many different things. Guardians are also required, typically annually, although some courts do it every 2 years, to file a plan. What services is the person going to get? What is the guardian going to focus on for the person as far as their goals? And an annual report about things like how often did you see the person? When did they go to the doctor? Most courts require you to get an annual evaluation from a doctor or a psychologist, a counselor, even someone on the DD team that confirms that the person still needs a guardian. And then there are occasionally times that you have to notify the court, like if the person moves, if there's allegations of abuse or neglect, or other changes in their condition. So you've heard me say this already, but guardianship isn't always the answer. And so if you're thinking about a need for guardianship, I think a good thought experiment is, if this is something you're concerned about, a situation you're concerned about, what would the guardian do to change that situation? And so if you're concerned about, for example, the person going out and spending a bunch of money. What would a guardian do in that situation that might be different than what a payee could do? And sometimes there will be a need and sometimes there won't be. And then it's also important to remember, not every decision needs to be made by the guardian. Daily decisions like what a person's going to wear, what they're going to eat, are they going to go to the movies tonight? Typically, a guardian is not involved in those kinds of decisions. And then it's important to know that there are limitations on guardianship. The law limits things like, are you the guardian of the person or the guardian of the estate? And what can you do with that? There are some very personal or invasive decisions that cannot be made by a guardian. So for example, we had a client who was in her 40s, and because of a medical condition, her doctors had recommended that she get a hysterectomy. And because a hysterectomy is a sterilization procedure, meaning she wouldn't be able to get pregnant or have a child after that, we can't make that decision. And so the court had to be involved in that decision for her. It's also important to know that a guardian may want to make a decision, but that they wouldn't be able to overrule someone else's rules. So in the DD system, where we come to this is there are certain things called restrictive measures that a provider or a county board might not be allowed to authorize, even though a guardian says, I want you to do this. And so a guardian can make some decisions, but they can't require someone else to break their own rules. So that's important to know. And then there's these practical limitations that I talked about before. We might be able to give consent for someone to get a medication, but if they're not going to swallow it, or if they're not going to sit for the injection, then that's not going to happen. We were very open to consenting to the COVID vaccines for our clients. We had clients who were very, very vulnerable with COVID. And so we were so happy that they were able to get the vaccines. But we have some clients who were able to say, no, I'm choosing not to get the vaccine. And so even though we consented, they did not get it because we're not going to hold somebody down and inject them with that. So those are some of those practical limitations that it's important to be aware of. People under guardianship do still have rights. This is definitely one of those gray areas, though. There's not always a lot of agreement. And so some things that are very clear are things like voting. People who have a guardian still have the right to vote. And so, if they choose to do that, if they want to make that decision to vote, they absolutely are able to do so. It's important to know that a guardian does not have the authority to vote on their ward's behalf. I have had some family members say that they thought they were supposed to, request an absentee ballot and vote for them. That is voter fraud. Do not do that. But if the person wants to vote, then they're able to do that, and they can get assistance to vote. Driving is another one. Sometimes we have clients tell us that they want their guardianship terminated so they can get their driver's license. And just like I talked about before, like incompetence to stand trial is not the same as incompetence for a guardianship. Same thing here. A person can have a guardian and still get their driver's license if they can pass the test and meet all of the requirements. There's a different process for a driver's license to be taken away. It's not just guardianship. One of the grayest areas of guardianship is this next bullet point, though: marriage, relationship, sexuality. And so I can't give you any really clear answers here, but generally we would say people may have more rights than you might think, because just like a guardian certainly couldn't decide for someone to be sterilized, they often cannot make decisions about how a person engages in sexuality if they have the capacity to make those decisions, if they understand what they're consenting to. Due process rights in guardianship cases are very important. So that means that a person who is under guardianship or under a guardianship application has the right to have an attorney appointed for them, has the right to an independent evaluation, all kinds of things that they have the right to protect them from that guardianship if necessary. And then, as I said before, rules like behavior supports and restrictive measures are also a right that the person has even if they have a guardian. So if you have determined that guardianship is necessary in your situation, here's kind of the general flow of how the process works. Attorneys are not necessary usually in guardianship. If you feel more comfortable working with them, having them go through the paperwork with you, certainly many attorneys are available to do that, but you often are able to do that on your own. Some situations where I might suggest that you meet with an attorney are if there's going to be a conflict. Typically, we would see that maybe if the two parents are divorced, there's a lot of conflict and both are going to apply for guardianship, you might want an attorney in that situation. But usually an attorney is not necessary. So the guardianship process starts by someone filing an application and paying the required filing fee. That application is going to provide information both about the person who needs a guardian and about the person applying to become the guardian. There's going to be a background check, there's going to be different steps that are taken, and there is a fee that is required to be paid. Now, I have heard from one of your local guardianship programs that there are some mental health providers in the area that if you are a client of that mental health provider, they may be able to help with that filing fee if that's a hardship for you. So certainly if you have difficulty with paying that, I would suggest looking into other resources that might be available. Once the application is filed, the court is going to schedule a hearing and the court is going to do what's called service. They're going to give the court papers to this group of next of kin. So usually that's going to be parents, maybe adult siblings, or if no one meets those criteria, then whoever that next closest family member is going to be. Before the hearing, at least 7 days before the hearing, the court investigator, which is usually a court staff person or contractor, is going to come out and meet. Pre-COVID, I would always say in person, but I guess it can be virtual now too. They're going to meet with the person who is proposed to be the ward, and they're going to give a report to the court about their perception of whether the person needs a guardian and the situation that the person is in. And they're also going to notify the person of the court hearing, of their right to an attorney, and all of those things. Then the court is going to hold a hearing. If there's no conflict, if it's pretty clear that the person needs a guardian and only one person has applied for guardianship and they pass their background check, it's a pretty straightforward process, nothing to be too concerned about. At that appointment hearing, typically you're going to take an oath of guardianship, you're going to sign an oath of guardianship, and then the court is going to issue you your letters of guardianship. And that is the court order that says to other people that you are the guardian. So I suggest getting a couple copies of that document, saving them in a safe place, giving copies of them to like the doctor, the service providers, the school, if appropriate, so that people know that you are the guardian. And then we go back to those ongoing responsibilities I talked about before, things like those 3-hour annual trainings, giving the annual report to the court, any notifications of changes or things like that. In Lake County, you have a probate court website. And so this is a good resource for the forms that you need. Last I checked, they had instructions and checklists, so you can go on their website. If you have questions about the documents, the court staff or the clerks, they can't give you legal advice, but sometimes they can answer your common questions, like which forms have to be filed, or what's the filing fee, or things like that. All right, so then before I get to the questions that are in the chat or opening it up for questions live, here are some resources. These two are specific to supported decision-making. So if you were intrigued by what I talked about with supported decision-making, I encourage you to check out these websites. The National Resource Center on Supported Decision-Making has more flyers, webinars, papers, research than you could ever go through, I think. So anything you're interested about with supported decision-making, you can find it there. The Jenny Hatch Justice Project is a really cool story of a young woman with Down syndrome who was one of the first people in this country to have a court recognize that supported decision-making was a good alternative for her instead of guardianship. So it's really inspiring. It's really encouraging. I can't recommend that enough. In Ohio, we've got some great resources. The Ohio Department of Developmental Disabilities has a guardianship toolkit, some resources pulled together on their website. Ohio's DD Council has put together a publication, a nice little booklet on guardianship and alternatives. And then Disability Rights Ohio also has good guardianship resources on their website. As I said before, you are welcome to contact me, especially by email, if you have questions after today. And so I'm going to go, I see a couple things coming through the chat. So I'm going to go through those and see what I can answer. And then Jody, if you want to open it up to questions there in the room as well. So let's see. Question about whether applying to be someone's guardian will look at the person, will look at your income as the guardian. Will it affect their Social Security income? The answer to that is no. Your income, I mean, the only thing I've ever heard a court looking at for income for a guardian is if you're becoming guardian of the estate. Sometimes there is a bond that needs to be filed or something like that. But Social Security's rules are always Social Security's own rules. And so their income, their asset requirements apply. If you're the parent, they apply whether you're the guardian or not. If you're not the parent, then they have no bearing if you are the guardian. And yes, great. I should have clarified this. So I talked about guardian of the person, guardian of the state. You can be both. You can be appointed as both guardian of the person and estate. Sometimes we call that plenary guardian, meaning everything guardian. And then looking at that timeline, as far as guardianship, you would need to check with your probate court. If you have a teenager, a 17-year-old who's going to turn 18, some courts will accept that guardianship application, 4 to 6 weeks before the person turns 18 so that they can get that process going. And then they'll schedule that hearing as close to the person's 18th birthday as possible. Other courts require you to wait until that 18th birthday to file the probate court forms, and then they try to schedule the hearing as soon as they can after that. Usually we see it within 4 to 6, maybe 8 weeks. So that's a good question to ask of your local probate court. As I was looking at that timeline at the beginning of the presentation, those are the kinds of things you want to be doing during that age 17 year, finding out exactly how your court's going to handle it, when you should file it, getting a copy of the forms, knowing how to fill those out, getting a copy of that expert evaluation, all of those things. Any other questions? Okay, so someone sharing Lake County says you cannot file until age 18. That's pretty typical. If there is an emergency, if they're going to need surgery, if they need someone making decisions every single day, sometimes you can go through like an emergency guardianship process. So again, something to ask the court about. But usually in the typical situations, that waiting period of maybe a month or so until the guardianship is finalized usually ends up being okay for most people. Any other questions? Sometimes I get questions, people have heard of co-guardians and whether, for example, mom and dad should become the co-guardians. Again, that's a question to ask for your court. If you have co-guardians, how they issue the letters of guardianship, because sometimes co-guardians are more trouble than they may be worth, because some courts interpret that to mean that both people have to sign everything. And if one person is taking the person to, the doctor or the hospital, you don't necessarily want to have mom and dad there each time. Whereas other courts kind of do it as an either or, one of them needs to sign, but not both. So typically we recommend not to do co-guardians. We say just pick the person who's going to be most involved, but it can depend on your situation.
Kristen, we have a question coming in from our group here at Deepwood. Okay.
I am not going to be able to hear. So if you just want to repeat the question after they ask it, that would be fine.
She's going to move up here where she can, where you can hear her. So if I become guardian of my daughter, but then I pass, is there something that I have to put in the will
because the older sibling is planning on taking over, but we don't want to have a co-guardianship to start off because she's gotta, she won't probably be around all the time at the beginning of this process.
Great question. Succession planning is a great thing to think of. And so the question, if you couldn't hear it, is if mom becomes guardian, what happens next? What happens when mom can't be the guardian? If mom passes away or otherwise is incapacitated, especially if there is a sibling, someone you want to be the guardian next. Ohio law does allow for a successor guardian, is what we call it, a successor guardian, to be nominated. That is not automatic. So basically what would happen is if something happened to mom or dad, then immediately that probate court would be fulfilling that superior guardian role. So if something needed to be signed off on, the court could do that. Or the court may have someone who they would appoint as an interim guardian. And then they would hold a hearing and have that successor guardian appointed. So it is a great idea, whether in a will or something like that, to nominate, suggest a successor guardian. And again, just like I said before, even if it's not automatic, if there's nobody contesting it, if there's no reason that that nominated person is failing a background check or something like that, it typically goes through pretty smoothly. There's another question in the chat about being guardian. Oh, Jody put that in, about being guardian and living out of state. That's another question for your local court. So under Ohio law, a guardian of the person could live out of state. But some courts don't think that that's wise. They don't feel like they have enough essentially control over or management of an out-of-state guardian. And so they decline to appoint an out-of-state guardian, or sometimes they require then co-guardians, an out-of-state person with an in-state person. Other courts allow it totally, especially if it's a family member, only for guardian of the person. The law is clear that a guardian of the estate cannot be a person out of the state.
Can you talk about educational power of attorney and psychiatric power of attorney?
Yeah, great questions. Educational power and psychiatric power of attorney. So when I talked about power of attorney, I mentioned that in Ohio law, we have specific approved forms for healthcare and financial. But a power of attorney is just a general term for, like I said, me asking someone else to act on my behalf. So you could work with an attorney, or at this point, there's probably some resources online that you could use to develop a power of attorney for anything. And so educational power of attorney is the one we hear of most. And that's this idea that after your child turns 18, the school says, we can't talk to you. You're not the decision maker. And so if your child is willing for you to make those decisions and be part of those team meetings, then the child could complete an education power of attorney that says, I essentially delegate my decision-making about my IEP to my parent, and I want my parent to be the one who makes those decisions and gets the information from the school. And I'm sorry, you mentioned one other specific term. Psychiatric. So again, that technically would fall under medical or healthcare power of attorney, but there are some specific psychiatric advance directives that a person can use to help direct their care or to designate someone to make decisions for them. So that really would follow that healthcare power of attorney. And powers of attorney can be limited. So if you're using the healthcare power of attorney form, you can limit it to psychiatric care, or you can exclude psychiatric care, or you can limit it to this time period. It's very customizable.
Are there any more questions in the room? Are there any more questions on the screen, on Zoom?
Stable accounts earlier. Okay, yes. A stable account, that's an acronym. ABLE account is what it's called under federal law, and it's like the Achieving Better Lives for Everyone. I forget exactly what the acronym is, but basically it's a way of maybe the person earns money from work or something like that. Maybe they get money as a gift from a family member. That money can be put into these stable accounts. It's managed through the state treasurer's office. And basically then any money that's in the stable account, they don't count against you for benefits. So I think a lot of people know that to be on Medicaid or to get housing assistance or what else? SSI, SSDI, all the benefits. They always ask you, how much money do you have? How much money do you make? Well, the problem with that is if you need Medicaid, you can never save for anything. How can you ever buy a house and be on Medicaid if they don't let you have more than $2,000? And so stable accounts were created to be a way that people can save money, use money for things that they want it for without getting kicked off of their benefits. There's a lot of great resources. If you just Google stable account Ohio, Ohio is one of the absolute leaders in the country on stable accounts. We were one of the first states to put it into place once the federal law was changed to allow it. We've got a lot of resources out there. The treasurer's office is very helpful. There's debit cards available. There's all kinds of things. The rules are very broad. The accounts were created to allow you to like support your daily living and disability related expenses, but essentially any way that your disability impacts your life, you can use stable accounts for. So again, housing, saving up for a house, going on a vacation, pretty much anything. It's like you can't buy lottery tickets or tobacco or alcohol. It's something like that. You know, that's the only things you can't use the money for. There are limits on how much you can put into account every year, but it's really growing. I really recommend it. I'm not an expert in it since we don't handle people's money, but lots of resources out there for you on that.
Kristen, let me save you here. I see several questions coming in about the stable account and trust and that sort of thing. So, so everybody knows we did have a family forum back in, I believe it was March or April, and it was a dual presentation where we did estate planning with Hickman and Lauder, and we did stable accounts, and we had the representative from the state treasurer's office come in and or actually on Zoom and discuss. So that Zoom session was recorded. The PowerPoints are on our website. So if you go to Lake County Board of DD.org, and you go to the resources tab and then family forums, you'll see all the family forums that we recorded, and that's where this one will also be posted in about a week or so. So take a look at that. Lots of good information. Like I said, there's PowerPoint. You can listen to the recording, and then there's resources where you can actually call or email additional questions if that information isn't answering the more specific questions that I'm seeing over here in the chat box.
Yeah, those are all very good questions, but I definitely recommend that you go to the experts on that since I'm not the expert. I will answer the last one though, because the criteria is if you're here today, the person qualifies because there's an age limit. You know, they had to have their disability by the age of 25. And so the definition of DD is you have to have acquired your disability by age 22. And so I'm going to say you probably qualify, but don't just take my word for it. Go listen to those presentations because they're very informative. There are a lot of details, but they can be really helpful in thinking about trust, the difference between trusts and stable accounts, all of those things.
And that's one of those recurring presentations that we will be coming back to probably each year, and probably back to Kristen again. I'm just giving you a heads up, Kristen. We'll probably be coming back to you again next year. I know. Just because, you know, we have a lot of families that may or may not have been able to participate or are just coming into the system and didn't get that opportunity, didn't know that that resource was there. So we'll continue those conversations in those family forums. For certain.
Great. And like I said, you know, I encourage the families here today to do it again, even if it's me next year, even if it's, you know, a topic that you've heard before, you'll probably pick something up or your situation will have changed a little bit and something will hit you a different way. So don't feel like you had to pick everything up today and know exactly how to apply it because it's complicated. There's a lot to it.
Are there any more questions in the room? Oh, we do have one more question. Can you come a little bit closer? Do you need multiple powers of attorney, or can you do like a power of attorney that talks about both psychiatric, IEP, whatever would be specific to that individual?
I think you probably could have one that covered everything. Because there's not a specific form for that, that's one where I would definitely recommend meet with an attorney for a couple hours and have them draw up the power of attorney that fits your situation. You know, it's not free, but it's also not going to cost you $10,000. You know, attorneys typically have pretty reasonable rates for things like this because it's pretty straightforward. You know, they've got kind of a template they might use that then they can tailor to your situation. So you definitely would want to meet though with an attorney because you want to make sure it's going to meet those legal requirements.
And I see in our chat box that Gabriella came in and talked about, you know, so you do have that fee that you have to pay in order to file for guardianship. And in some cases, if individuals are receiving family support services here through the county board, they may be able to use those funds to assist with that cost. I know that people have, when it was a really, you know, a financial hardship, we have the Deepwood Foundation that we can approach for a grant. So we do have resources here in Lake County as well. And individuals, if they are receiving SSI, that is actually something that they can use that money toward as well. So
Good to know.
okay. Any other question?
If I do the guardianship, do I need to worry about powers of attorney, or is that covered under that?
If it's the same kind of guardianship, then so for example, if you've got guardian of the person, you wouldn't need a healthcare power of attorney. If you've got guardian of the state, you wouldn't need a financial power of attorney. But it's possible that if the person, you know, needs a guardian of the person, but has enough capacity to designate a guardian of the estate or the other way around, that is potentially workable. Again, I'd probably work with an attorney on that to make sure that there's clear evidence that they have capacity for one thing, but not the other. But definitely, if you've got guardianship, you don't need the same kind of power of attorney. There's kind of a detailed legal process where if someone has a power of attorney and then they get the guardian, the power of attorney actually continues to operate. So the power of attorney would have the ability to act instead of the guardian. It's kind of complicated. I would definitely talk to an attorney about that situation also. But once you have guardianship, you certainly don't need to create a healthcare power of attorney. It's not going to give you any additional authority. And potentially it would be found invalid if the person had been found incompetent to make those same decisions.
Any other questions from the room? Okay, any other questions from the Zoom? Yes, lots of kudos. We thank you so much, Kristen, for joining us. It's a great presentation. We really, I know that the SSAs, myself, our social workers were able to listen to you a few months ago, and everybody was absolutely, you got to bring her, you got to get her for a family forum. So.
Well, thank you so much. I'm so glad to be here. I appreciate being able to do this by Zoom. And again, please do reach out to me if you have questions that come up later.
Very good. All right, everybody. Thank you so much for joining us. We appreciate it. We'll see you soon.